Good afternoon. My name is Sam Hinkle, and today I will be presenting on conflicts involving airline labor unions and litigation after the COVID 19 pandemic. The pandemic itself created the largest operational disruption the aviation industry has ever faced. Passenger demand collapsed almost overnight as governments imposed travel restrictions and borders closed. Because of this, the legal framework, airlines could not simply alter work rules or compensation structures without following the formal procedures. I will endeavor to explain how these legal protections created conflicts during the pandemic and how courts interpreted the laws during that crisis. So, to understand the issue, we need to understand the scale of the disruption. In early 2020, global airline passenger demand dropped by more than 60%. Entire fleets were grounded, and many routes were completely suspended. Airlines rely on constant passenger flow to generate revenue, so the sudden drop created a major liquidity crisis. However, the airlines still had to pay their aircraft leases, maintenance costs, airport fees, and employee wages. Labor agreements negotiated with unions were still legally binding, which limited the ability of the airlines to immediately adjust operations. This created a difficult balance between economic survival and contractual labor protections. Labor conflicts emerged because airlines needed to quickly adapt to a financial emergency. Airlines began reducing schedules, consolidating routes, and offering voluntary leave programs to employees. From a management perspective, those steps were necessary to avoid bankruptcy. However, unions believed that some of these changes affected negotiated work rules such as scheduling systems, reserve assignments, and pay protections. When those rules are part of a collective bargaining agreement, they cannot be changed unilaterally. The Railway Labor Act is the key law governing airline labor relations in the United States. It was originally passed in 1926 for the railroad industry and later extended to airlines in 1936. The purpose of this law is to prevent labor disputes from disrupting national transport systems, i.e., railroads or airlines. The law requires negotiation, mediation, and sometimes federal intervention before strikes or major operational changes can occur. This structure promotes stability but can also limit flexibility during economic crises like the COVID 19 pandemic. A central concept within the Railway Labor Act is the difference between major disputes and minor disputes. Major disputes involve creating or modifying the collective bargaining agreements. However, during these disputes, employers must maintain the existing conditions until negotiations and mediation are completed. Minor disputes involve interpreting existing agreements rather than changing them. These disputes are typically resolved through arbitration rather than court intervention. During the pandemic, many lawsuits focused on determining whether airline actions were major disputes requiring bargaining or minor disputes that could be resolved through arbitration. One of the most important Supreme cases related to the Railway Labor Act is the Detroit and Toledo Shoreline Railroad versus the United Transportation Union. In this case, the court emphasized the importance of maintaining the status quo during major disputes. Employers cannot change working conditions until the statutory dispute resolution process has been completed. The court explained that by allowing unilateral changes, this would undermine the entire negotiation structure created by Congress. During the COVID 19 pandemic, unions relied heavily on this precedent when arguing that airlines could not change certain employment conditions without bargaining. This was the case in many of the airlines. They were attempting to change something, but they couldn't because of this court case. They were hemmed in by the Detroit and Toledo versus the United Transportation Union decision. Another important case is the Consolidated Rail Corporation v. Railroad Labor Executives Association. This decision clarified how courts should determine whether a dispute is a major dispute or a minor one. The court created what is known as the arguably justified standard. If an employer's interpretation of a contract is reasonably plausible, the dispute is considered minor and must be resolved through arbitration. This standard is differential to employers. During the pandemic, many courts used this precedent to determine whether airline operational adjustments were allowed under existing contracts. In this instance, what it's basically saying is that this case allows for the court to allow the employer to determine. So if they have a reasonable view of the contract that they have with the union or the employees, and they decide, and the company says this is allowable to what we think, in some cases, because of this case, the court would essentially rule or decide not to rule in favor of the decision that the employer was making, as they had decided that they were justified in the decision-making process that got them to that point. The pandemic's impact on airlines. The operational impact of COVID-19 on airlines cannot be overstated. Airlines grounded aircraft worldwide and suspended numerous international routes. Many companies parked their wide-body aircraft and delayed aircraft deliveries. Even though revenue dropped dramatically, many fixed costs remained the same. These included aircraft financing, their maintenance programs, gate agreements that they had with airports, and regulatory compliance standards. The sudden loss of revenue forced airlines to search for immediate cost reduction strategies while still maintaining operational readiness for eventual recovery. In some cases, this meant that they increased the prices, or if they were regulated, they couldn't. But all the while, any debts that they had could still be called on. There was not a precedent to allow them to be like, hey, we are literally unable to make money, so we need to be able to, have some relief here. But in this instance, the way that everything was set up, they didn't. The federal government responded to the aviation crisis through the CARES Act. This legislation, including the Payroll Support Program, which provided billions of dollars in financial aid to airlines. The goal was to preserve aviation jobs and maintain the nation's transportation infrastructure. This is something the federal government does pretty commonly with large industries such as this or the banking industry. The federal government will step in cases of extreme emergency, because it will either, in some cases, there's the statement, sometimes it's too big to fail, or that if it does fail, it will create an even more catastrophic problem down the line because of the failure of this. Such in this case would be the failure of an airline, right? The airlines do a lot of movement of people, do a lot of movement of cargo across the nation, so they couldn't. So this is something that couldn't fail, which is why the federal government stepped in with the CARES Act. The funding came from conditions such as limits on layoffs and restrictions on executive compensation. While this support stabilized the industry temporarily, it did not eliminate the operational challenges that the airlines faced. Labor disputes still emerged over how companies implemented schedule restrictions and other operational adjustments. A lot of places, the cargo still kept moving, but in some cases, like the mostly passenger liners, so your American, your Delta Airlines, Southwest Airlines, they were unable to compete or do anything because in some cases there was restrictions where people couldn't move, or later on in the COVID crisis, they may have had to limit how many people they could have on their airplane. So like one person per row, while they're still making money, the ticket prices may have been higher because there was only, they could only take a third of what they were allowed to take. From a union perspective, the central argument was that the pandemic did not suspend federal labor law. Unions believed that certain airline actions effectively changed negotiated working conditions. For example, modifications to scheduling practices or pay protection systems could alter compensation structures. Under the RLA or the Railway Labor Act, those types of changes require bargaining. Union leaders also emphasized that employees had already negotiated these protections through collective bargaining agreements and that these agreements should remain enforceable even during economic crisis. What they were arguing is that there was no clause that helped protect the airlines, and they still had the employers, the companies still had the owed responsibilities to the union members to protect them. Airline management presented a different perspective, obviously. Executives argued that the pandemic created an unprecedented financial emergency that required rapid operational adjustment. They relied heavily on management rights, clauses contained in collective bargaining agreements. These clauses often allowed airlines to make decisions regarding scheduling, fleet deployment, and staffing levels. Airlines argued that many pandemic-related changes were simply interpretations of existing contracts rather than modifications. In this case, they were arguing that they would have to be interpreted this way because of the economic crisis. And after it was over, once everything got back to normal or started to trend that direction, they would move back to the before interpretation. Under the consolidated rail precedent, those disputes would therefore be classified as minor and have to be resolved through arbitration, so not going to court. Courts review these disputes and generally relied on existing RLA precedent rather than creating new legal rules. Many cases were classified as minor disputes because the airlines were able to demonstrate plausible contractual justification for their actions. As a result, courts frequently directed the parties to arbitration rather than issuing injunctions. This approach preserved the structure of the RLA while allowing disputes to be resolved within established legal channels. The judiciary's decisions demonstrated that the legal framework governing airline labor relations remain stable even during an unprecedented crisis. Looking beyond the immediate crisis, the pandemic revealed several long-term implications for airline labor relations. One key lesson is that the importance of crisis planning within collective bargaining agreements. Future contracts may include clearer language regarding operational flexibility during emergencies. The pandemic also highlighted how critical cooperation and trust are between labor and management. Airline operations require coordination among many professionals, and sustained conflict can negatively affect operational performance. I think that is something that everybody can relate to. They can see across the board, across all things, how much things have changed in terms of what the pandemic did to everybody, right? For almost a year after the beginning of the pandemic, people were still wearing masks at work. They were maintaining social distancing. Even now, obviously, it's creating a potential for, what happens if this happens, right? Obviously, everyone thought that we were in a newer era where pandemics couldn't happen, but the COVID-19 pandemic definitely opened up a lot of people's eyes to this is still possible even in this day and age with how sanitary things are now. It is still a possibility. From a biblical perspective, principles of justice and stewardship provide guidance for evaluating these disputes. Proverbs 11:1 emphasizes fairness and balance in agreements and transactions. Collective bargaining agreements represent negotiated balances between labor and management responsibilities. Luke 16:10 highlights the importance of stewardship and integrity. Organizations entrusted with these resources and their authority must act responsibly and transparently, especially in times of crisis. These principles reinforce the importance of ethical leadership and good faith negotiation. So, recommendations that came out of this. Several recommendations emerged from the lessons of the pandemic. Airlines and labor unions should consider including emergency authority clauses in future contracts to clarify how operations can be adjusted during crises. The industry could also benefit from expedited arbitration procedures that allow for the disputes to be resolved quickly. In some cases, the arbitration that occurred didn't happen fast enough, and people were spiraling into debt or just not having money because they were not being paid or they were not working. Improving communication between management and labor representatives may reduce the likelihood of litigation during future disruptions. I think this one circles back into number one as well, where they go, something happens, right, and a communication has to happen, right? Hey, we are enacting emergency clause X, Y, and Z because of this. Letting them know, telling them, hey, this is going to be happening. You need to tell your people to prepare for this. By preparing all of these mechanisms by the three, right, collating the clauses, expedited arbitration, and strengthening communication, it can help the industry respond more effectively to unexpected events. In conclusion, the COVID-19 pandemic placed extraordinary pressure on the airline industry and its labor relations system. While airlines faced severe economic challenges, the RLA continued to regulate how employment conditions could be modified. Courts could largely upheld the existing legal principle and directed many disputes towards arbitration. The experience demonstrated both the resilience of the RLA framework and the need for improved crisis planning. Moving forward, the industry must apply the lessons of the pandemic to strengthen cooperation between labor and management and prepare for any future disruptions. These are the references that I used. That is the end. Thank you.